The Supreme Court and the Election Commission have occupied the headlines in the media this week. The Apex Court has been asking the government one question. Tell us, how do you select the election commissioners? The government is stonewalling. It's telling the five-judge bench, it's none of your business. It's not the business of the judiciary to know how the election commissioners are appointed. It's the government's prerogative to choose the chief election commissioners and the election commissioners. And the government uses its wisdom to do it. Only one who can question this is the President of India, because the appointments are announced in her name or his name. If it's okay with the President, nobody else matters. Anyway, there is separation of powers between executive and judiciary. Why should the judiciary encroach into the territory of the executive? This was the pointed submission of the three highest officials of the land: the Attorney General, the Solicitor General, and the Assistant Attorney General in the Supreme Court before the five-judge bench. But the Constitution bench, headed by Justice K.M. Joseph, did not buy this argument. They said it's the duty of the government to place the facts before the judiciary, and it's the duty of the judiciary to intervene when the constitutional position is either flagrantly violated or the constitutional imperatives are not complied with. The court drew the attention of the lawyers about the Article 324 of the Constitution that provides the setting up of the Election Commission. The Constitution, of course, did not lay down the process by which the election commissioners will be appointed. It left it to Parliament to do this, to do the legislation. But unfortunately, in the last 72 years, from the no government, from the one headed by Jawaharlal Nehru to the one headed by Narendra Modi, nobody bothered to move a finger in this regard. Why so? It's because no government would like to tie itself down with rules. Because the moment you make rules, then if you breach it, you will be liable for explanation before the court. You will be subjecting yourself to judicial scrutiny. And that's the reason no government has ever done anything to lay down the rules. As it stands today, election commissioner is appointed as per the whims of the government. And the whim is a whim. It cannot be called in question, isn't it? That is the stage in the argument in the Supreme Court, when activist lawyer Prashant Bhushan drew the attention of the court to a recent appointment of an election commissioner. In fact, it happened last week. See how the game was played, he told the court. One Arun Goel, who is a serving bureaucrat applied for voluntary retirement on Friday, 18th November. The government approved his application for early retirement the very next day, 19th November, which was a Saturday. The very same day again, the government appointed Arun Goel as the election commissioner. He joined the election commission on Monday, 21st November. Why this tearing hurry? The court asked. The Trinities, the top three lawyers, told the court that this government acts expeditiously in all matters. It's in a tearing hurry in everything because it wants to accomplish its missions very fast. The court appreciated the fact that government, by its own admission, is prompt in doing things. So to test its promptness, the court asked the legal luminaries to produce the file concerning the appointment of Arun Goel the very next day. The AG, Attorney General and his colleagues were taken aback. They had not expected that their laudatory words about the government would boomerang on them. They tried to buy more time to produce the file, but the judges were insistent. After all, it's a hyperactive government. If the government can approve the voluntary retirement application of a bureaucrat in one day and appoint him election commissioner the very same day, it can very well have no difficulty in presenting the file in 24 hours. The top lawyers were clearly flabbergasted. They were issuing commendation certificate about the government, about its speed of decision making, and it came back to haunt them. But anyway, the very next day, the government lawyers presented that file before the court. It was yesterday. And what did that contain? Since Arun Goel had applied for voluntary retirement, his name was proposed to the Prime Minister. But the file said his was not the only name. There were names of 3 other sundry IAS officers who had recently retired. Was there any process through which these 4 names were selected? The judges asked. They received no answer. A man with any common sense will surmise this. Arun Goel, who has proved his loyalty, possibly, was asked to apply for voluntary retirement so that he could be immediately appointed as election commissioner. His post-retirement engagement is now secure for the next 5 years. Will such men not be more loyal than the king? The Supreme Court is raising the right question about the process of selection of election commissioners. But the remedy it is suggesting is possibly not the right answer. What is it saying? It's saying Chief Justice of India should be a part of a committee to select the election commissioners. But then just see. The Chief Justice of India is in the same committee to select the CBI director. But the CBI has been doing the hatchet job for the government in power for all these years. CBI was a caged parrot in 2013, as the Supreme Court described it. It continues to be a caged parrot in 2022. Then CJI's presence did not make any difference. if the constitution bench can force the hand of the government to pilot a bill in parliament, to lay down the process to select election commissioners, that would possibly help reinforce the credibility of the poll body as the neutral umpire in the electoral game. Let us hope for the best.